keeping today's remarks short.
We have with us today some of the most distinguished members of the legal fraternity. Ms. Geeta Luthra is a senior advocate who practices in the Supreme Court of India and various high courts. She currently serves as the Vice President of the Indian Council of Arbitrators, FICCI, and as the core committee of the ICC India chapter. She has additionally provided special counseling in leading environmental matters in the Supreme Court on behalf of the Delhi government. We welcome you, ma'am. Can we have a round of applause? Mr. Ketan Paul is an advocate on record practicing before the Supreme Court. He is a partner at Curium Legal. Mr. Paul currently serves as counsel for the center and various state governments. His litigation experience spans work across several courts and tribunals, including matters dealing with key issues of constitutional, criminal, and commercial law. We welcome you, sir. Mr. Anil Airy is an eminent legal practitioner and a senior advocate at the Supreme Court of India. Mr. Airy serves as the panel of arbitrators at the DIAC and has represented a large number of business houses. He has also appeared before the ICC and DCAC. We welcome you, sir.
Mr. Tanveer Ahmed Mir is one of the most celebrated criminal lawyers in India with over 2 decades of experience. He has defended accused in cases like the 2G Spectrum case, the Arushi Talwar case, the Ryan School murder case, and the Sheena Bora case. Thank you for gracing us with your presence today. Mr. Ganesh Chandru is a partner at Dua Associates, our knowledge partners for today, without whom this event would not have been possible. He specializes in international and domestic arbitration and commercial litigation. He has been recognized in the Global Arbitration Review as a significant name and has been recognized as one of the future leaders at Who's Who Legal and the Global Arbitration Review. An avid mooter himself, Mr. Chandru has represented India at the Jessup Moot Court competition. We're extremely grateful to have you here today.
With this, we are ready to commence our final rounds today. Our finalists for today are Team Code 3, who will be acting as prosecution, and Team Code 16, acting as our defense.
As we will be live streaming the event, we request our audience to remain seated throughout the session to avoid disturbances. With this, we invite our judges to commence today's final rounds. Thank you.
Counsel seek permission to approach the bench. Counsel seek permission to address the bench collectively, Your Honours. Much obliged, Your Honour. Your Honours, I'm Counsel 1. I'm a co-counsel. We are here on the behalf of prosecution in the present matter of State versus Aldron and others. Your Honour, prosecution would like to start with the opening statement under section 226 of CRPC for prosecution side. Much obliged. Your Honour, this is a simple open and shut case of a cold-blooded murder of a woman who worked all her life for the betterment of the people. Ms. Obstentia was not only a second-generation lawyer, but also has created in her state not once but twice by being the only female contender for the post of Chief Minister. Her murder not only puts into the question the safety in the society, but also the undermined transformative ideals of the Constitution. Counsel state that Mr. Aldron is the party under section 319 of the CRPC, as he had planned this murder conspiring with Mr. Brutus and Mr. Sashius. Mr. Aldron planned all this by arranging that Mr. Obstentia to be at a certain place at a certain time, as during her murder she was under house arrest only on the mere charges of defamation. Mr. Arnott laid down the plan for Mr. Brutus and Sashius to murder Ms. Obstentia. Your Honor, the presence of Mr. Brutus at the crime scene, the digital evidences, a witness statement given by the accused, and the murder weapon recovered from the witness directs and prove beyond reasonable doubt that he can be charged for the charges of murder. An agreement between two or more, sorry, Your Honor. Your Honor, all the evidence is directly pointing out towards the conspiracy to murder. It is clear that Mr. Aldon, Brutus, and Sassius are involved in murder of Ms. Obstentia, and all the elements of criminal conspiracy will be proven by the prosecution. That is, object of accomplishment, or a plan or scheme of accomplishment, and an agreement between two or more people to accomplish such act. An agreement, Your Honor, it is humbly submitted that there is enough evidences to believe that all the three accused are involved in the conspiracy to murder. Proof of agreement was present between the conspirators. The prosecution will be providing the court with evidences and the witness statement to prove beyond reasonable doubt that the accused is guilty for the crime they are charged with and must be punished under section 302 and 120B of the Penal Code. The counsel would like to state the facts and the event what happened on the night of 23rd Jan 2023. Commander's Table's tweet sparked the violence against Ms. Obstentia, promoting increasing the security around her residency. Mr. Brutus and Simba, police constable, were deployed for the security of Ms. Obstentia during her house arrest. Around 19:15, Babulal and Simba heard the distressing sound from her. Brutus, leading to the apprehension of a clock stranger, Brutus near the premises. Brutus, who confessed to being the of the chosen one and implicated the accomplice of Mr. Sassius. Simba discovered Obstentia lying on the floor of the blood around her, and immediately called ambulance around 9:25 p.m. Obstentia dying declaration hinted at the betrayal of Arnold. Subsequently, Sassius was apprehended near the bus stop at 9:26 p.m., providing further collaboration to the Brutus confession. Additionally, a murder weapon was seized from Brutus' possession and adding to the incriminating evidence against him. Your Honor, the counsel would be proving the timeline of the event at the night of 23rd and the evidences collected by the state. The counsel will be calling Head Constable Simba to address the confession given by the accused and the evidence collected from the Brutus. Then we'll be calling Constable Simba to tell the court about the crime scene and the condition of the victim, that is Ms. Obstentia. Then Dr. Debbie to state the dying declaration stated by Ms. Obstentia. Sure.
So, for prosecution, you stake a claim that the judges frame a charge.
Judges frame the... no, sir. No, Your Honor.
What do you claim then? That you have 3 sets of oral witnesses, you have documentary evidences. So you want to begin the trial, so you would request that the charges be framed and you be permitted to get your witnesses to the witness box? Yes?
Yes, sir.
Yeah, all right.
So, in case, the case of the defense is that only Brutus was liable with some other persons as conspirators, would conspiracy still lie?
Indeed, Your Honor. Your Honor, Brutus was charged for section 302 as for murder, and Mr. Aldon and Sassius were charged for the conspiracy. If the murder is not proven by Brutus, then charges can't be proved further.
So then you think we can have them discharged?
According to the evidences, Brutus, for the Brutus, they can't be acquitted.
What about others then? What about the other 2 defendants or other 2 accused then?
Your Honor, the circumstantial evidence is proving their collaboration for the murder.
Right. Do you have direct forensic evidence as well?
We have some forensic evidences. It is on discretion of the court to admit it.
Although I know that we're not to ask you about procedure, but why do you believe that WhatsApp messages can be admitted? Do you know, or are you aware of this? I know this is not your scope of your query.
Indeed, Your Honor. Your Honor, according to Section 65B of the Indian Evidence Act, any any digital evidence is admissible to the court if they are presented as secondary evidence. If it is the primary evidence, it can be admissible on the court directly without any application.
So my question to you is, what part of the WhatsApp messages shows conspiracy with Brutus and Cassius, between Brutus and Cassius?
It was a command given by the commander in the WhatsApp chats that will be presented in further case.
Thank you.
Much obliged.
What are your names? I think we were supposed to know.
Speaker 1, Chirag.
Chirag. Speaker 2,
Adit Shah.
Adil Shah.
Adit, A-A-D-I-T.
Sorry,
A-A-D-I-T.
A-A-T-I-T. And you are C-H-A-R-A-G. That's it.
Indeed, Your Honor.
Adit Shah. Defense Speaker 1. Vidhi Vishnu. Okay. Speaker 2. E-R-A-J-W-A-M. Yes. B-E-R. And Burma B-E-R. So Speaker 1, Chirag. Speaker 2, Adit Shah. Defense Speaker 1, Vidhi Bishnoi. Defense Speaker 2, Prajwal Verma.
Who is going to do the opening from defense? Would you want to go ahead?
Thank you. Greetings. I appear before the esteemed bench as the counsel for the defense. If it pleases the bench, the counsel would like to address the bench as an honorable bench.
Yes, permission granted.
Honorable bench, on an informal note, the counsel would like to submit that since the memorials are prepared issue-wise and the structure of the trial is opening and closing, I would be dealing with issue 1 and my co-counsel after chief and cross-examination will be dealing with issue number 2 and 3. Honorable bench, it is very humbly submitted that the prosecution has presented a very beautiful case, but unfortunately, they have haphazardly made evidences that had no submitted evidences, presented evidences that has no evidentiary value in the court of law and is more like a puzzle of loopholes. The story may be fantastic, but the evidences presented have absolutely no backing and is insufficient in the court of law. Honorable bench, neither were my clients in the house of Miss Obstentia that night, nor they have committed any murder or criminal conspiracy. Honorable bench, it is very humbly submitted by the counsel that the two accused, namely the FIR, had absolutely no motive to kill Miss Obstentia, and my third accused client, that is Mr. Al Ron, has been maliciously dragged into the case just because he was defamed by Miss Obstentia, and after that he filed a criminal defamation case against her. Additionally,
So
honorable
you're
bench,
concluding she is defamed. She's only accused of defamation. So are you concluding she was defamed? Is there a conclusion to that?
honorable bench, it is very humbly submitted that Miss Obstentia's remark were practically said to maliciously and intentionally damage the image of my client during peak election season when he has nothing to do with the murder of Miss Obstentia. He is the incumbent chief minister of the state of Romulus. He is in lead. A student poll was conducted wherein the percentage of his exit polls were much higher than Miss Obstentia's. He had no motive, no intention to kill Miss Obstentia in the first place. Additionally, honorable bench, it is very humbly submitted that it is merely a political move to frame my client so that his political trajectory is interrupted and his image is tarnished in the political
What do you
field.
call this intention? What is called legally?
Honorable,
His intention, you say he doesn't have this intention to kill her. What do you call it in the legal criminal law?
Honorable, Your Lordship, it is very humbly submitted that intention refers to that the motive.
Criminal intent, what is it called?
Criminal intent refers to that I have a motive
No,
to.
there is an expression used for criminal intent in criminal law. Sir Singh, do you know the expression which is used? Are you remembering? Mens rea?
Yes.
Yes?
Yes.
Or that's what's, and what is the other thing? Apart from mens rea, what do you have?
Advocacy,
Yes. Okay, go on.
Honorable Bench, it is very humbly submitted that the council will categorically be proving the above said facts that how all of my clients are not at all involved in the present matter, and the council is here to prove that the prosecution has failed to prove the case beyond reasonable doubt, and my clients are not guilty. And with respect to issue number 1, I would like to submit that the evidences presented before the Honorable Court is not sufficient and is not credible to implead Mr. Alron as a party under section 319 of the CRPC. Honorable Bench, it is my very humble submission that my accused client Alron doesn't have any prima facie case made out against him. It is only the letter of Miss Obstentia's family on the basis of which he has been implicated in the present matter. And no one, there is no record of the, Honorable Bench, it is very humbly submitted that there is no one on record to prove the contents of the letter that was filed by Miss Obstentia's family that Mr. Alron has an involvement in Miss Obstentia's murder. Honorable Bench,
Mr. Defense Counsel, is it not a fact that the High Court, being a constitutional court, has already directed the trial court under section 319 to add your client Elron
Honorable Bench,
as an accused to face a trial for murder and criminal conspiracy?
Honorable Bench, it is my very humble submission that the Honorable High Court directed the Sessions Court to consider the possibility of impleading Mr. Alron as a party to the present trial. And it is my very humble submission, Your Lordship, that if the Honorable Bench may refer to page number page number 14, paragraph 10. The council would like to submit that in the case of Shiv Kumar Yadav, the accused summoned under section 319.
Yes, submissions. He is giving the submissions. Memorial. We haven't got the memorials.
If you don't have a copy, don't worry. Just
Give us
make
the
a submission.
memorials in the meantime.
Honorable Bench, in the case of Shiv Kumar Yadav, the accused summoned under section 319 was neither mentioned in the FIR nor any prosecution witness made a specific accusation against the person. The order of 319 was set aside. In the present case, Honorable Bench, the testimonies in the previous trial of the witnesses in the previous trial, no witness has mentioned the name of Mr. Alron in their testimonies.
What is it? Then doesn't she give a dying declaration regarding Al?
Honorable Bench, it is very humbly submitted that
Al can't be anybody else but Alron.
Indian leadership, Al can be anybody.
No,
anybody.
I'm saying it can be nobody else. You are saying it can be anybody else. I'm saying it can be nobody else.
Honorable Bench, it is very humbly submitted that all the evidences produced that the knife had an engraving of Al, the dying declaration saying that Al had did this, in no way states that Alron was involved in the murder.
But at the stage of framing of charge and triggering a trial against your accused, we only are required to see the prima facie case. On what basis and reasoning are you asking this court to reject the dying declaration of the deceased given to an independent witness who not hold any grudge against you.
Who is the person to whom the dying declaration was made?
Dr. Devi Shetty already.
So, is that admissible, you think, a dying declaration to a
No,
doctor?
Your Ladyship. The proper procedure of recording of the dying declaration was not conducted. There was no one to corroborate that even Dr. Devi Shetty received the dying declaration or not. It could be fabricated.
What would be the reason for the doctor then to give a false statement?
It could be a politically motivated reason, Your Lordship.
Can we consider that argument at the stage of charge?
Honorable bench, it is very humbly submitted that after chief examination and cross-examination, the counsel would be dealing with all the issues in the closing statement. The
Alright.
counsel,
Go on, he is fair, it's fair. You go on.
Very well.
Fair.
Very well.
honorable bench, the counsel would like to submit and conclude the opening statement with the argument that Mr. Alron had no involvement in the murder of Miss Ostentia. In this identity.
Your case is that Mr. Elron doesn't deserve to be charged and that he should be discharged, but the other person should be put to a trial.
No, Your Lordship. I am also pleading that Brutus and Cassius also had no involvement in the murder case. Just because they have a vulnerable background, they have been framed in the present matter.
Who saw Brutus in the balcony? Somebody saw Brutus in the balcony? Or jumping
No,
from the balcony? No.
It is claimed by Head Constable Babu Lal, who was drinking on duty, that he saw. How can we accept a police official drinking on duty that he saw that someone jumping from the balcony? What credibility does a...
For that purpose, sorry for interjecting, for that purpose, the court will have to give an opportunity to Babulal to testify on oath
Indeed, Your
and
Lordship.
also give you an opportunity to demolish his case in
Indeed,
cross-examination.
Your Lordship. Indeed.
Then how are you saying that all of your clients deserve a discharge right now?
Honorable bench, the council is placing arguments in the opening statement based on the previous testimonies given by the witnesses. After the chief and cross-examination, the council will demolish the credibility of the prosecution witnesses.
You will make an attempt.
So according to you, what do they have to establish in order to satisfy the threshold of 319?
Honorable bench, it is very humbly submitted that there is no legitimate or valid evidence produced before the court. Only on the basis of the letter of Miss Optentia's family that Mr. Alron had a involvement in the present matter, the Sessions Court has ordered the implication of Mr. Alron in the matter. No substantive evidence has been produced before the court.
According to you, it has to be only proper substantive evidence indicating this person's involvement. That is what you're saying?
Honorable bench, a complete chain of events should be satisfied. Circumstantial events should lead to a case that Mr. Alron was involved in the present matter.
And will that not be gone into in the trial?
Sorry, Your Lordship.
Will that not be gone into in the trial?
Yes, indeed, Your Lordship. I'm
It's a matter of
repeatedly
trial,
saying that after chief and cross we will in the closing statement.
Mr. Counsel, are you aware between the difference between the propositions of substantive evidence and admissible evidence at the stage of deciding whether your clients are to be put to a trial or not?
Somewhat, Your Lordship.
Can you make an attempt? When does a piece of evidence be called and termed as a substantive piece of evidence?
Your Lordship, it is very humbly submitted that when the evidence can lead to a conviction of an accused, it can be said as a substantive evidence.
That the evidence which is needed for convicting an accused has to be credible, cogent, and convincing.
Indeed.
Substantive evidence is a piece of evidence which is made in the presence of the accused. That only happens during the course of the trial, when the witness steps into the box, takes an oath, and in presence of the accused and the defense counsel, he makes the statement. That is why a statement recorded before a police or even before judicial magistrate under 164 is never termed as a substantive piece of evidence. So at the stage of charge, your argument has to be the evidence presented by the prosecution at the moment in form of prior statements of the prosecution witnesses, and even the documentary evidences are not good enough to trigger a trial. You cannot use the word substantive evidence at this juncture. All right.
Just carefully, you have three accused. You may have a conflict of interest.
So does the prosecution now, is that,
Yes.
does prosecution now want to lead and bring the prosecution to this one?
The head constable.
All right, then we decide that the trial will trigger and we will summon the witnesses. Let the trial begin.
Head Constable Babulal, please take the stand. Your Honors, if I am audible, I would prefer not using the mic.
More than audible, not an issue at all.
Thank you, sir. Sir, could you please raise your right hand and repeat after me? I solemnly and sincerely affirm
I solemnly and sincerely affirm
and declare that
and declare that
the evidence I shall give to the court
the evidence I shall give to the court
touching the matters in question
touching the matter in the question
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you very much, sir. Could you
Got
please,
the last part, so help me God.
so help me God.
Help.
Could you please state your name and relevance to the case for the court?
Greetings to the council. My name is Babulal and I'm the head constable.
And how are you exactly related to this present case?
So I was assigned the surveillance of Miss Substantia's house and I was stationed near the alley beside her house alongside my sub-constable.
Can you please tell us about the night of the incident?
Sure. So on the night, it was really cold and we were drinking hot water mixed with very little amount of rum to survive the cold. And around 9:15, we heard a small shriek voice. Startled by that, we observed what was going on, and around 2 minutes later, I saw an individual in a cloaked figure jump from the balcony.
Point to me noted, Your Honor. Please continue.
So I ran after him and I instructed Sub-Constable Simba to check on Miss Substantia's house. After a minute, I catch hold of him and he was murmuring, "It is done, it is done." Immediately after being caught, he pleaded me not to harm him and said that he was merely following the orders of the chosen one.
Immediately after being caught.
Yes.
Point to me noted, Your Honor. Please continue.
And he said he's merely following the order of the chosen one and his companion Cassius can be found near the bus stop. So I instructed my fellow police officers to go to the bus stop and see if there is any suspicious individual. Also, I seized from him a knife which was serrated and it was blood-stained knife. And the letter AL was also engraved in it.
After you bagged and tagged the knife, did you send it for forensic analysis?
Yes.
Are you aware of the forensic analysis of the knife that was done?
I'm aware that it was the major weapon for the murder.
It was a murder weapon. You're aware
Yes,
of that.
yes.
Much obliged. Your on lordships, the forensic analysis is given on page number 34 of the proposition. We would like to mark it as Exhibit A. Much obliged. So, to your best knowledge, the knife that you confiscated from Mr. Brutus was deemed to be the murder weapon.
Yes.
Much obliged. Point to be noted. Let's move on to the million-dollar question, which I'm pretty sure a defense is going to ask. Were you drinking that night?
So we were drinking hot water mixed with very little rum. So I don't think I was.
Leading the witness.
Objection sustained, you cannot ask this question.
Answer. Can you comment on the mental state that can you comment on your mental state and that of Simba on the night?
I can speak about myself. I was mentally competent and I was fully aware of my surroundings.
Were you completely cogent?
Yes.
Much better. Point to me. No further questions.
Council seeks permission from the Honorable Bench to proceed.
Yes, please step forward.
Mr. Babulal, To save precious judicial time, I will be asking you short questions, and I request you to answer either in yes or no. If the question is not in yes or no, try to use a couple of words. Was that be fine with you? Okay. Is it true that you were drinking on duty?
No, I was not drinking.
I asked a question in yes or no. Can you please answer? Were you drinking on duty?
Mixed with a little.
Objection to that, Your Honor. The question is one which does not warrant a yes and no answer. The witness has clearly stated he was not indeed drinking on the duty, but in a manner it was a diluted.
Honorable Judge, Honorable Bench, is the witness not here? Does the counsel still need to take a stand for the witness?
The defense does not allow the witness to complete their answer.
All right.
This question can't be answered in a yes or no, perhaps. So she can say yes or no and then give the complete answer.
Sustain the objection. We will permit the defense counsel to reframe the question.
Head Constable Babulal, on the night of 23rd, were you carrying a flask of rum that you were sipping rum from?
I was carrying a flask of hot water and a very little amount of rum was mixed in it.
So rum was mixed in it. Thank you. One more question. Head Constable, was it foggy that night?
No.
Which floor was the balcony on?
So the balcony was in the first floor.
Okay. Can you tell me the approximate height of the balcony?
I'm not quite sure about the approximate height, but it wasn't that.
Still, an approximation would work.
Objection asked and answered.
Objection overruled.
I would say around. It was such that a man can jump.
Can you give us a number, please?
All right.
Needs to be noted, Honorable Bench. You described that you had a frenzied moment while arresting Brutus. Is that true?
No, I didn't.
Head Constable Babulal, can you please answer me on when did you look at the knife?
When I was interrogating Brutus, I saw the knife near the shoes. It was in between his socks.
When did you confiscated the knife from him?
The exact time.
No.
The exact time.
No, not the time, the moment. Can you describe the moment for me?
A minute later,
Can you describe the moment for me, please?
So when I ran towards Brutus, I catch hold of him, and he was murmuring, "It is done, it is done." And then I observed that there was a knife beside his socks, and I took hold of it.
Can you tell me whether you were wearing gloves while taking the knife from him?
No, I was not wearing gloves.
Okay. Thank you. That would be all, Honorable Bench.
Does nobody want to ask the witness, either prosecution or defense, that something who about the chosen one? I mean, should the prosecution ask the question that what do you mean by the chosen one, or does the defense want to ask who's the chosen one? Why do you connect the chosen one to Amand or anybody, Alner, whatever? I want to ask you this question. How? So there's some statement that he says the chosen one had told me to do it. But how do you link the chosen one to the conspiracy?
Your Ladyship, the prosecution can answer this question as of now. However, we would request we answer that in our closing statements if permissible by this court.
No, my question is why to that constable, when the constable has, or when it's being said that this is what he said, there is nothing which is linking yet the chosen one so far.
Indeed,
Am I right?
indeed, Your Ladyship, as of now in the course of the trial, nothing has been
Right.
linking
Or
the chosen.
very-
You have a separate witness.
We do,
for
sir.
that. All right.
Yes.
Thank you very much.
Yes, yes.
Mr. Madam Defense defense counsel, can you please tell the bench, in your cross-examination, why is there no suggestion to the prosecution witness insofar as recovery of the weapon is taken into consideration?
He says that the recovery is tainted, but beyond that,
So is your case that the recovery is planted, foisted, or are you now, on the dint of your cross-examination, admitting the recovery?
Honorable bench, my very humble submission is that from my client, a knife was never recovered. That is my stand.
Then why no suggestion to the witness that I put to you that this knife was never recovered from your client and that it has been planted subsequently? Very well.
well, such a suggestion should have come. All right, but well done anyway.
Your Honor, witness number 2, Constable Simba.
Constable Simba, please take the stand.
Repeat after me. I solemnly and sincerely affirm
I solemnly and sincerely affirm
and declare that the evidence
and declare that the evidence
I shall give to the court
I shall give to the court
touching the matter in question
touching the matter in question
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and the nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you. Your Honor, before starting, I would like to state that Simba is the constable at the crime scene.
With
So,
Babulal.
with Babulal.
That's his relevance. All right.
Sir, can you please state your name for the record?
Certainly. My name is Constable Simba. I have been on the force for 4 years now. ma'am.
And how you are connected to the case?
I was present at the scene of the crime under my head constable Babulal.
Can you please tell the court what happened exact that time?
Certainly. So, as had been mentioned by the Honorable Constable, at 8:30 p.m., we were stationed after the risk had emerged following the tweets at 6:30 p.m. Subsequently, at 8:30 p.m., due to the cold of the night, it was 5 degrees Celsius after all, we did sip a little rum diluted in warm water. Subsequent to this, at 9:15 p.m., we heard a loud shriek from Miss Obstentia's house, the alley next to which we had been deployed. After hearing the shriek, acting on the constable's orders, I proceeded towards Miss Obstentia's house. After scanning my surroundings on the first floor, what I did observe was that Miss Obstentia lay on the floor in a pool of blood, sustaining severe injuries to her chest as well as her stomach. As a result, I had called the ambulance promptly, which arrived at 9:25 p.m., and the ambulance had taken Miss Obstentia to Badra General Hospital at 9:35 p.m.
Sir, you just stated you entered the house directly. The gate was open.
Indeed.
It was not locked.
Indeed, the gate was open as well as the door was unlocked.
Door was unlocked. Whether there was any kind of lock on that?
Certainly, there was a biometric lock on the door.
Thank you so much. So you just stated you were drinking that night. Can you tell the court, were you in your senses that time?
Absolutely.
Question disallowed. That's leading directly, even without the intervention of defense.
Obliged.
Reframe the question.
Sir, can you please tell, were you in your senses?
Absolutely. I was in my senses. A minimal amount was diluted in warm water for the sole purpose of keeping us warm.
Mr. Prosecutor, why are you doubting your own witness by asking him whether he was in his senses or not?
Your Honor, this is to present that the witness was there at the crime scene. The amount he was consuming was not enough to yeah.
He just stated that upon hearing a shrieking cry, he went up to the floor where he found a body in pool of blood. He called an ambulance, and thereafter the body was taken.
Indeed, Your Honor.
In terms of he seeing the dead body, his testimony is already done.
Your Honor, the crime scene he visited, the observation he made that the window was open, the door was unlocked, to make a point on that point that he was in his senses and he was not missing any point, just to establish this point.
Very well. Please remember that on part of material aspect of testimony of a witness, you not to lead, and you only to give an introductory statement. once the witness gets into the material aspect of testimony, he has to say on his own. All right.
Indeed. Mashallah. Cross, please.
Hello, Constable Simba. I put to you that your agency was aware of the tweet by Soldier Sable. Is it true?
Indeed.
Is it true that despite the knowledge of the tweet, the security for Miss Obstentia was not increased?
It was for this, it was out of the risk that had emerged that I, along with Head Constable Babulal, had been deployed at the site. We were the security.
Except for you and Head Constable Babulal, was there anyone else as a guard on the main door?
At the time of the crime, no.
Were there CCTVs installed at the main gate or the balcony, since it was apparently enough height to jump off from?
Honorable Counsel, to this regard, I would like to clarify that at 6:30 p.m. the tweet had occurred. We were deployed at 7 p.m. and the crime occurred at 9:15 p.m. In such a short span of time, would it not be unrealistic to expect the deployment of CCTV cameras?
Thank you so much for fulfilling the role of your counsel. Constable Simba, can you please outline for me what was the size of the flask that you were drinking from? How much was the quantity of the rum in it? How much was the water in it? Were the flasks of the same size for both of you?
Certainly, there was a single flask of 500 ml present at the time. I would expect that approximately 100 ml of rum was present in 400 other ml of warm water for the sole purpose of keeping us warm in the cold of the night.
Is it true that you were drinking on duty?
Objection, asked and answered.
The point is already, he said that I'm drinking fine. Where are you going with this?
I rest my cross, Honorable Bench.
Much obliged, Your Excellencies.
He presented the witness.
Chief.
He examined the chief.
Deceased was under house arrest.
Indeed, Your Honor.
So he waited for a tweet to get two constables to go. What is the meaning of house arrest? There has to be somebody guarding the house. Right?
Your Honor, that time only two police constables were deployed after outside the house. There was no one else.
Why do you have to wait for a tweet? You are supposed to have the police. The person is house arrest. Should you not have enough?
Indeed, Your Honor, the police have deployed more constables there, but at that particular night, for her own safety, only two police constables have been deployed there.
Dr. Devi, Dr. Devi, please take the stand.
Dr. Devi, with your right hand raised, please repeat after me. I solemnly and sincerely affirm
I solemnly and sincerely affirm
and declare that
The evidence I shall give to the court
the evidence I shall give to the court
touching the matters in question
touching the matters in question
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth. So help me God. Greetings to the bench.
Thank you, Ms. Devi. First of all, before I start, might I congratulate you on your recent baby daughter. Can you please state for the court your name and your relevance to this present case?
My name is Debbie Shetty. I am a doctor by profession, specializing in general surgery. I am a head trauma surgeon at Bhadrar General Hospital, and I oversaw the treatment of Miss Obstentia.
Can you tell us about the night of the incident?
So on the night of the incident, I was the one who examined Miss Obstentia. When she was brought in, I observed that she had 11 stab wounds, 8 across her stomach and 3 across her bosom, and she was unconscious and she was bleeding. And out of the 11 wounds, 2 lacerations were fatal, and they were caused by a serrated weapon like that of a saw or a serrated knife, and it would most likely cause pain to the victim, immense pain.
Thank you. Can you tell the court about the dying declaration that you recorded?
Yes. So, seeing her critical condition, I and my team, we immediately got to work, and I told my team to handle the less grievous wounds while I focused on the two major lacerations. And I was preparing for the operation. I had administered the blood tubes and the saline drips, and I was telling my team that her chances of survival were minimal. And during that time, she regained consciousness and she pulled me and whispered that I really loved him, but Al betrayed me. He did this.
What happened after that?
After that, she took some deep breaths, and within 30 seconds to a minute before we could do anything, we lost her.
Just one question to the witness, generally for the purpose of, I know you're participating as a, you said that you told your team, and you said we. So along with you, there were others as well during that time?
Yes, sir, yes. In the operation theatre, there was a team.
So when she said something to you, could it be possible that they heard it as well? Or-
Sir, I do not know about them, but I certainly heard.
Okay, thank you.
So is pain relevant? You said the two wounds were very painful, I could tell. But how is the pain relevant in a case of a trial under 302 read with 120B? What is relevant factor?
Ma'am, there were chances that the pain might cause her death.
Pain doesn't cause death.
No, she might succumb to her injuries. Like
No, that's a different thing. Injuries may cause death. They may be sufficient to cause death. How is pain relevant, doctor?
it led her to become
For
unconscious.
pain, you can always give a painkiller.
Yes.
So how is pain relevant to causing death?
Ma'am,
I'm just telling you, pain is not relevant. It'll be the sufficiencies of the two injuries, which you have said actually, that two of the injuries seem to be fatal and could have caused the death. So that's what's relevant, not the pain aspect. Pain, you give painkillers. Now, when she whispered to you, I really loved him. Are you trying to help the prosecution in proving the case that there was a dying declaration?
ma'am, I am.
Or you're not trying to help the prosecution, you're trying to help the defense? I just want to know. You've come as a prosecution witness. So if you are trying to help the prosecution or arrive at the truth, did you try and find out if she was conscious, she knew that she will die? Do you know that one of the aspects that you have to perhaps tell her is that you may not survive? Did you see the state of mental being of the patient?
Yes, ma'am.
Or was she being vindictive? Did
No,
you think?
ma'am, to the
I mean-
best of my knowledge and observation, I think she was conscious, she was aware, and she was coherent. I could understand what she said. So, according to me, she was mentally stable.
She
at
knew
that
she
time.
might die?
Yes, I believe she heard her. She heard us. Like when I was telling my team that she had minimal chances of survival.
Do you normally tell it in the hearing of a patient that, look, you're going to die?
Ma'am, she was actually unconscious, and I was trying to, boost my team that we need to fight. We really need to fight for her life.
Yes. So was she unconscious or was she conscious?
Ma'am, I do not know that, but I realized it the moment she pulled me, and then she whispered, and
All right.
she took her last
Sorry,
breath.
you want to ask some more questions?
Mr. Prosecutor, this witness, does she sign a post-mortem report?
No, she does not, sir.
Does she have a forensic testimony?
She does not, sir. Sir, it is submitted. She is merely a trauma surgeon in the nearest near
Trauma
hospital.
doctor.
She has nothing
Surgeon.
to. Yeah, she is not the
Surgeon
general
to whom
attending.
confession has been,
Indeed.
dying declaration
Indeed, your lady.
has been made.
Much
Who
obliged.
wants to do the cross? Yes. Take the mic if you want.
I would be fine without the mic. Dr. Debbie, Can you please tell us, or tell the court in fact, why did you ask your juniors to stitch the less grievous wounds?
So there were various wounds, and I did not want to, waste time. So I told them they are experienced, they could handle. So while I focus on the major wounds, you at least seal the less grievous wounds.
Dr. Debbie, you say, and you quoted that while dying, Miss Obstentia stated that I loved him, he betrayed me, Al did this. Did she specify what this was?
No.
Thank you. You, in your chief, mentioned that she was in a critical condition and the survival chances were minimal. Do you have any evidence on you to prove that she was in a mental state to give a dying declaration of the sort?
So
A yes or no answer, please.
Objection beyond the expertise of the witness. The witness is a trauma surgeon, not a psychologist.
Sustained. Reframe the question.
Dr. Debbie, do you know what a BHT is?
Objection. The witness has been called to attest to the dying declaration. This forum should not be turned into a referendum on her skills as a surgeon. It is the contention of the prosecution.
Honorable bench, my very humble submission, given that she is a surgeon, she definitely would be knowing firstly the rules of the medical council, and secondly the procedure to be followed in a violent crime case.
Yes, you can ask these.
Do you know what is a BHT? Let me give a better word for it. Do you know what is a bed head ticket?
yes.
What is it? Can you please tell the court?
So basically, it is a chart that has the medicines and the treatment that is given to the patient from the time the patient has come to the time of discharge.
To your knowledge, Dr. Debbie, has the BHT been submitted to the Honorable Court?
Objection. The relevance of this question, sir.
Objection is overruled. Answer the question.
To your knowledge, Dr. Debbie, has the bed head ticket been submitted as an evidence to the Honorable Court?
I do not know. The records would be with the hospital if you're looking for the records.
Dr. Debbie, before preparing for the surgery, did you or did you not call for an anesthesia expert, or did you give an anesthesia?
I did not give the anesthesia because it is the duty of the anesthetic surgeon, and during that time he wasn't available. So
Is it a common practice
Objection.
to
I believe
operate?
the witness was still answering.
Just go slow. Yes.
Dr. Debbie,
The
is it a
witness was not done answering the question, the earlier question.
So generally, we couldn't wait for the anesthetic surgeon to come. It was the matter of life and death. Each second was important. So anesthesia is generally given to a person during the surgery to make them unconscious so that they don't feel pain. Miss Obstentia, when she came to us, she was already unconscious, and we did not have anesthetic surgeon. So what we did was we gave her an numbing agent. That was lidocaine.
Did you conduct any X-ray, CT scan, MRI?
No. At that point of
That
time,
would be enough. I rest my cross.
Redirect, Your Honor.
Hang on a minute. Redirect. Madam Defense Counsel, why is there no question from the defense that if there is a dying declaration, whether she recorded it anywhere, including the BHT?
Honorable bench, my very humble submission is, given that in the previous trial itself, it has been mentioned in the proposition that she only has an oral statement to give, it has not been recorded to save the precious judicial time. I did not understand.
Sir, redirect, please.
Redirect on what ground?
On the ground that the main testimony of the doctor needs to be highlighted before this honorable court.
All right.
Much obliged. Dr. Devi, asking you the question once again. Did you record the dying declaration?
This redirect we will not allow.
Indeed,
That
sir.
is improvement and getting more knowledge.
Indeed not, sir. I would just like the doctor to reiterate the facts that she already has.
That she had to say in her first chief.
She has.
She said that I heard,
Indeed, yes, sir.
but she didn't record it. So you only have an oral statement, you don't have a documentary corroboration.
Your Lordships, it would be submitted that recently the Supreme Court in the year 2023, in the case of Parangauda and another versus the state of Karnataka, have noted that in the absence of the doctor's certificate is no longer factor enough to ipso facto make the dying declaration inadmissible.
That's a final argument.
That's an argument point. It's a good point, but it's an argument point.
Much obliged. No further question.
Yes, please.
Your Honours, at this point we would like to have an objection for the record. We are yet to receive a 315 application. They are the accused that are being called.
It's a substantive right of an accused to testify as a competent witness. Doesn't need a formal application.
Indeed, sir. I would just mentioning.
Yes. Here you go.
I solemnly and sincerely affirm
I solemnly and sincerely affirm
and declare that the evidence I shall give to the court
and declare that the evidence I shall give to the court
shall be truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the
So
truth.
help me God.
So help me God.
Brutus, tell the Honorable Court what is your name and occupation.
Honorable Court, my name is Brutus Legidarius. I am a biometric salesperson.
Where were you on the night of 23rd January and what were you doing?
On the night of 23rd January, I had just concluded my workday. I had just reached home. I had a heated argument with my wife, and this argument led me to leave to cool down. And I had just left. I was just walking around in my own neighborhood, and it was a foggy day. Out of nowhere, a man comes and he charges at me, and he just pushes me, and we wouldn't reason. He was like a rabid dog. He wouldn't let me reason with him. I tried to ask him what grounds if I was being arrested for or apprehended for, and he did not say. And he just pulled me to the car and he dragged me and he took me from there.
What interaction did you have with Head Constable Babulal on the night of 23rd?
Objection, foundation, it was not established. It was Mr. Babulal who came charging him as a quote-unquote rabid dog.
It is very humbly submitted, Your Honorable Bench, that the Moot proposition
He's right. You have to ask who is it who charged or do you identify before you go on to this question. You can ask the question, but do it with two stitches.
Brutus, tell the court who apprehended you on the night of 23rd.
Police officer Babulal.
Okay. What interaction did you have with Head Constable Babulal on the night of 23rd January?
I wouldn't call it a conversation. It was just me trying to ask an individual who was brutally holding on to me. He couldn't pull me that way also. He was moving while he was pulling. He himself was not in a state where, he could, I can't explain it to the court. It was brutal. He just dragged me from there and he put me in the car.
Did you confess anything to Babulal?
Absolutely not. I was only trying to reason of why I just wanted to go home. I just wanted to be with my family.
Do you know who Cassius is?
Sorry, sir?
Do you know who Cassius is?
Yes, I'm aware. When I was taken to the police station, I was brutally tortured with another individual. His name was Cassius. They were shouting.
That's all. Cross.
Thank you. Could you please describe to the court how you were tortured?
You don't want to establish his link with Cassius or any non-link? So you don't want to ask him that there is nothing, no, you and Cassius didn't have any conspiracy, no? Or just sit.
Can you please describe to the court how you were tortured?
During the day of when I was tortured, I was made to lie around. My hands and legs were tied. With a rubber rod, they hit my legs and my hands. And after that, they made me walk and
All right,
clap
thank you.
with my hands.
You said you were beaten, right?
Yes, sir.
All right. Are there any marks we can see?
They made me walk and clap. Those, I don't know, surprisingly, they made the red marks go away out of my hand.
How obvious. All right. You said you were paraded around naked around your wife, correct?
That would be correct.
All right. Where is your wife right now?
She's not here. I did not want to make her relive this torture.
So you're being tried for murder and you did not want your wife to be here as a witness for you? How convenient. Point to be noted. Is it by any chance possible that your wife is not here, attesting to the fact that you were indeed tortured in front of her, maybe because she's a bit scared of perjury? You don't need to answer that, it's just a rhetorical question. You said that you were tortured. You said your hands were tied. You said you were beaten. But you don't have a single shred of proof to show any kind of police brutality whatsoever. Is that correct? Just a yes or no, please. Yes or no? Do you have
Yes.
proof? What is the proof?
I am not of Romulus. I came to Romulus a few years ago, and I've ever.
Sir, if you wanted to make this a political forum, I would give you a soapbox. Could you please stick to the question I asked? Do you have a proof?
Sir, a humble submission to the court. If I could only make a statement, will I be explained?
Answer the question, it is direct.
I have had to see a lot of my friends who have come from abroad being faced this racism, and they have had to face the same treatment before. So even though they tell me, and it has been seen that they were dragged out of that court, I have seen them come back with a lot of pain but no stains on their body.
So we would like the court to remove this last statement that he made. Again, he was not answering the question. Again, just a yes or no question. Any marks on your body that shows you were beaten? Yes or no?
No.
Any evidence or any person or any witness comes here and attests to the fact that yes, you were paraded around naked around them?
My wife.
Yes, is she here right now?
No, but if
So
she
no.
has to come, she should. She will.
She will. All right. So when she does, we will consider that. As of now, yes or no?
Could you repeat the question?
As of now, is there any witness that can prove that you were tortured? Yes or no, sir? Please. Let's just not waste the time.
I couldn't understand the question. Could you repeat it?
Any witness who can agree to the fact.
Sir, could you move a little? Thank you.
No, you need to be a bit slow, you're too fast.
Any witness who can agree to the fact that you were tortured.
My wife.
Who's not here? Point to be noted. No further questions.
My lordship, anything to wait that person, the police officer who had come back to the family after that.
And she'll say, yeah, you too,
You
Brutus.
haven't asked any question about the planting of a knife. You haven't asked any question that there was a knife. Both people haven't asked the most vital question, I feel. But you know the case they are setting up. You have no knowledge of the case against you. Then why are you coming in the witness box if you don't know the case? Of course, they had no possession, but there has to be something by the defense and by the prosecution with regard to the imaginary knife which the prosecution is creating, which has a DNA. So don't talk about DNA because you are not maybe expert on DNA, but something you have to say about fabrication. Anyway, go on. I'm just saying that that part had to come, according to me, from either of you or both of you.
Your ladyship, the mere fact that the prosecution, that the defense has not raised that question and that question has not been rebutted, means that the testimony given by Mr. Babula under oath has to be taken as the actual testimony, and hence we did not raise any questions regarding that.
Will the honorable bench allow me to put forth an answer to that?
Yes, of course.
Honorable bench, my client has told and spoken about everything he knew. That is all from his knowledge, and everything has been recollected by my client from his own knowledge and own mind. Except for that, no other question has been asked to him.
And he doesn't even think he was drunk. He says he was brutal, but he's not, according to him, drunk, unstable on his feet. Because somewhere you have brought out that he is hallucinating. Then where's the hallucination come if you don't even allege drunkenness to him when he meets you? I mean, that's just my thought. But
Indeed,
that's fine.
indeed, ladyship.
You are presenting your witness under 315 if your case is that he was put to torture, was he ever medically examined?
Your Lordship, my very humble submission is that my colleague from the prosecution started off with the constitutional rights, yet the prosecution has not respected the guidelines of DK Basu in the first place. There is no medical examination on record.
Your Lordships, I would like to ask a question. I would like to respond to that. I would like to ask.
I think we're not arguing just now. Let's go to the next witness.
Your
The
Ladyship,
case is over.
if the court might allow me one question to ask to Mr. Brutus, not to the counsel, just to clarify this.
That would be on a redirect. So first you have to establish a ground for re-examination. Without that, we can't permit.
So the ground being that the prosecution has just intimated that a constitutional wrong has occurred?
That's an argument.
Answer it
Indeed,
to
sir.
That's an argument.
When you do your closing, tell us all this. Can this poor witness leave?
Yes, yes, Your Ladyship.
You too, Brutus.
Beaten by might, beaten by
Defense witness 2, please approach. the
Defense
desk.
witness 2, Cassius, please take the stand.
Raise your right hand and repeat after me on oath. I solemnly and sincerely affirm and I declare
I solemnly and sincerely affirm and declare
that the evidence I shall give to the court
that the evidence I shall give to the court
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Cassius, tell the honorable court what is your name.
Your Honor, sir, my name is Cassius Musanis.
What were you doing on the night of 23rd January and where were you?
Sir, I was at the bus stop waiting to catch a bus back home.
Do you know who Brutus is?
Sir, if I don't mind asking, can you tell me what point of the time are you referring to?
General.
When I was at the bus stop, I did not know a Brutus. I have met the man Brutus when I was later arrested and tortured by the police.
Have you ever met Brutus before you both were tortured at the police station?
No, sir.
On honorable bench, I asked my witness, have you ever met Brutus before the police tortured you both? He's
us so leading. So put it in another way.
okay. What interaction did you have with the police that night?
Sir, I was waiting for the bus when a policeman approached and they arrested me immediately. I asked them what was going on. I was very confused, but they just asked me to shut up. I was very panicking. I was scared. I was not from the place. So I just went with them.
That's all. Cross.
Approach.
Yes, please.
So, Mr. Sashius, can you please tell the court what you do for a living?
Sir, I'm a game developer.
Okay, you're the game developer. Okay, perfect. We'll start with your roots now. Are you the citizen of Romulus?
No, sir.
Are you sure?
I was not born in Rome.
Are you the citizen of Romulus?
No, sir.
No.
No.
Your Honor, please refer to the memorandum. Pay number.
Objection, honorable bench. Since we have limited time for closing and opening, the time cannot be used for argumentation.
The time has been allotted differently. A witness statement given by the memorandum, the credibility shows that the witness is the citizen of Romulus and has been recently the citizen of the Romulus, basically. Have you given any statement to the police?
Sir, before that, if you don't mind me clarifying, I'm a citizen of the state called Sokar. It is a different state in the country of Anglovia.
Sir, my simple question was, are you the citizen of Romulus?
No.
Right now. No. Point to be noted, my lord. Okay, next question. Same, as I've already presented. Have you given any statement to the police?
I was forced to, sir. I did not give any statement.
Okay, you're the forced. You were tortured?
Yes, sir.
Is there any marks?
No, sir. They tortured me in a way where it internally
Thank you so
hurt.
much. Have you any kind of report?
Allow the witness to answer.
Indeed, Your Honor. Please.
I was beaten with a rubber rod on my arms and soles, and then they placed a cloth on my hips and used some sort of a thick leather piece, and they hit me, and then they asked me to clap my hands and walk bare feet. Honestly, the entire process was very humiliating.
Have you any kind of report to the present in the front of the court?
Sorry?
Have you any report to show the court that you have been tortured?
I have no idea regarding this.
Okay, no problem. Can you please tell the court what was recovered from you? Is there any phone recovered by from you by the police? Yes
Sir,
or
I
no?
was arrested and they seized my phone.
Okay. Point to be noted, my lord. This will prove. This will be proven by the further evidences.
Sir, when I was arrested, my phone was seized.
Is that all? That's all. Fine. Witness discharged.
Honorable bench, with your permission, the council would like to present defense witness number 3. Raise your right hand and repeat after me. I solemnly and sincerely affirm
I solemnly and sincerely affirm
and declare that the evidence
and declare that the evidence
I shall give to the court
I shall give to the court
shall be truth,
shall be truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the
So help me God.
So help me God.
Defense witness number 3, tell the honorable court what is your name and occupation.
My name is Anron Dukshin and I am the CM of the state Romulus.
Where were you on the night of January 23rd?
I was at my residence the whole day.
How were your relations with Miss Obstentia?
Well, the question was what about the night of 23rd, not whole day. Where were you night?
I was at my residence.
How were your relations with Miss Obstentia?
She was my opposition leader, so yeah, it was just whatever our relations were, they were all professional. We just met at gatherings, social gatherings, or any political party gatherings.
Okay, thank you. That's
Mr. Aaron, could you please describe your party flag for us?
Yes, it is kind of rhombus in shape, and it is having 4 leaves on the sides.
Thank you very much. Point to be noted, Your Honor. A partial print of their party's flag was also found in the murder weapon. It is part of the forensic report. Could you tell us the history of your party, please?
Yes, RSS basically was already existing party, and we can say that Romulan Raiders, they were the successor of RSS.
Thank you very much. Point to be noted, Your Honor. Could you please tell the court your relationship with General Allen?
Yes, he was my relative. My spouse,
How is he related to you?
My spouse brother.
What do we call that?
Brother-in-law.
Thank you. Who's your father-in-law?
He is his name is Sony Regulus, and he is the monarch of Nomalia.
So he's the king.
Yeah.
Thank you very much. What kind of ideology do you share with the Crusaders Reborn?
I have no.
Objection is overruled.
Much obliged, Your Lordship.
Our ideologies are completely different, so I am not.
Your ideologies are completely different. Okay.
Yes, so-
Then can you please explain to the court how is it that every time your government faced a no confidence motion, there was a unrest in the entire country led by Crusaders Reborn?
I am not aware of this.
You're not aware of how obvious. Crusaders Reborn is led by your brother-in-law. Is that correct, General Allen?
I am not aware of this.
You're not aware of that as well. Do you believe General Allen or your brother-in-law to be enemy of the state?
No, I don't think so.
You don't think that an infiltrator is enemy of the state? Wonderful. Point to be noted. Is it true that in the recent, you've been a chief minister for how many years?
This time I am contesting the elections for the 3rd time.
So 10 long years.
Yes.
My God. All right. So is it true that in the recent polls, it was very much evident that Miss Absentia was gaining lead and there was a very good chance that it was a very tight election?
Yes, we could say that.
Thank you. Point to be noted. Is it true that as chief minister of the state police comes under your jurisdiction?
Yes, it does.
Yes, point to be noted. Is it true that as the chief minister of the state, you would be a man of considerable power?
Obviously.
Thank you. Point to be noted. No further questions.
Would the prosecution like to make their closing statement? Thank you.
Counsel seeks permission to approach the dais.
Yes.
Much obliged, Your Honors. Counsel seeks permission to begin.
Is it okay if I skip the mic?
Yes, of course.
Much obliged. Your Honors, for the convenience of the closing argument, I would like to address the bench collectively as your ladyship, if that is convenient.
Perfectly all right.
Much obliged, Your Ladyship. Your Ladyships, this is a very, as my co-counsel started, this is a very open and shut case. A cold-blooded murder, and as a result of conspiracy of three people, Mr. Brutus, Mr. Cassius, and Mr. Allen. As has been noted in this court by the direct examination and the chief examination, the defense has not been able to poke any relevant holes into the testimony given by the prosecution witnesses. Mr. Alron has come to the stand and agreed how he is in fact the power wielder in the state. He has agreed how he is in charge of state police. He has agreed how he is connected to the general Allen of the Crusaders Recon. It is nowhere beyond a doubt that he holds considerable power, and if there was any, he clearly mentioned against it. Let us take in the opportunity to lay down the overwhelming evidence that is present against Mr. Cassius and Mr. Brutus in this present trial, and link that to the murder of Ms. Absentia as how it absolutely does. For the first and foremost, Your Lordships, it is contended that the confession, apologies, I forgot to give complaint. The confessions given by Mr. Brutus and Cassius have to be held with the highest regard and have to be deemed admissible in this court of law. As has been laid by the Honorable Supreme Court in the case of Kadi Ogad, flag number 1 of the flag, as long as a confession, to challenge the admissibility of a confession, two factors need to be proven before this honorable court. One, that the confession, at the time of making the confession, the person making said confession was an accused. And secondly, the person must be compelled or tortured or put under duress to make said confession. None of these factors have been proven, have been negated by the defense. It is clearly, humbly presented that as Mr. Babudar mentioned in his testimony, as soon as he ran and caught Mr. Brutus, seeing that he was a police officer, Mr. Brutus has blurted out that yes, I did it on the command of the chosen one. My co-conspirator is over there. At that moment, he was not under the ambit of an accused, and hence the question of 20 sub clause 3 does not apply. Furthermore, the question of compelling the witness or putting them under duress or putting into any other conditions which might alter the statement given by them. It is submitted that the onus to prove any and all kind of police brutality, if any, lies on the person making said orders, and that is not the words of the counsel, but that of the Supreme Court in the case of Tukaram versus State of Maharashtra. The moment the statement given to the police is challenged based on police brutality, the onus shifts to the defense, and the person specifically alleging said violence to prove that he was brutally beaten, which has clearly not been done in the present case. Both the people who have challenged the statement and have mentioned that they have been brutally murdered, they have been brutally beaten up, have stood here on the stand taking an oath and mentioned to the honorable court that there is not a single scar on their body that they can prove to show that okay, this is how I was beaten. Furthermore, Mr. Brutus has on paper, he says he has a collaborative witness, his wife. His wife is not a party, is not a witness of the defense. His argument is that he has not called his wife to save her from the mental trauma of the trial. The man is going, if convicted, he is going away for life. He is being charged in a murder. And his argument is that he does not want to put his wife through this. Either he is a very loving husband or he has been lying. Either of them are not cogent enough reasoning to not have a concrete witness be present in this honorable court of law. And hence the confessions need to be taken into consideration, and which directly prove the culpability of Mr. Brutus and Mr. Cassius.
Does it answer 27? The confession that is being made, does it lead to any recovery? Is the confession made to a police officer good?
In relation to the confession made to Mr. Brutus, the confession made by Mr. Brutus directly led to Mr. Cassius, from whom the phone was confiscated by the police, which has not been disputed by either of the parties. Following which the chats have been recovered. That is the second part of the argument that counsel will be going on. The
Mr. Prosecutor, you are overwhelmingly stating that the wife did not testify. How does that buttress your case? All that the wife could testify is that my husband and I had an altercation and he left for a walk. The wife would not be then a witness to what happened on the spot and on the crime scene.
Indeed not, sir. It is the statement of Mr. Brutus on the stand that he was paraded around and ridiculed. He was paraded around naked and ridiculed in front of his wife. His wife could have very well come to this honorable court and at least attested to that. A wife is not even considered a relevant witness when it comes to such collaboration or such corroborations because it goes directly to bias. However, taking that bias into consideration, the wife is not here giving a statement that has to speak volumes against the veracity of the claim that has been made by them. For the second set of the arguments, Your Lordship, if the defense were to contend that
Mr. Prosecutor, as the accused has taken the stand that he was tortured, would you limit the torture only to physical beatings and rule out a confession drawn by mental torture? One of the witnesses said that I was made to crawl. So every torture would not indicate any kind of injuries on the person, on the body, on the skin.
Indeed, Your Lordship, but even so, as the labor honorable Supreme Court, the onus to prove still rests on the defense, which they have not done. Furthermore, Your Lordship, a very important point to be noted, as the defense counsel pointed out, that constitutional principles have been violated. If indeed they believed in any merits in the torture and they actually had any evidence whatsoever, there would be n number of PRs and writ petitions they would have filed in front of the High Court and the Supreme Court, asking for police brutality and violation of the fundamental rights.
So was your client not under a constitutional obligation in terms of D.K. Basu to have the accused medically examined before they were produced before the magistrate?
And Your Lordship, we have very much done that. It has not been contended up till this point of trial in any of the fact sheet that they were not shown before a medical examiner. The only contention is that they were tortured. I would very much appreciate that the defense not come at the juncture of the trial and add on facts as it suits them and whatever else further they call.
So tell me, what according to you is the law of conspiracy? Because ultimately two people you are bringing in only under conspiracy. So what is the law of conspiracy? And how do you bring both of them?
Relation for that, I would like to
Cassius and
was this court's attention to page number 18 of the proposition, which mentioned the chats that have been recovered from Mr. Cassius's phone.
they are not admitted, they are not proved.
Your Ladyship, it is
None of your witnesses have proved the
Your
charge.
Ladyship, indeed not Your Ladyship. In fact, also contends that Mr. Cassius has agreed on stand that his phone was confiscated. Following the guidelines of Arjun Pandit Rao, recently reinterpreting the guidelines set in Anwar, Justice Nariman has very clearly said that the absence of that the 65B certificate needs to be produced only when the original evidence is not there and only secondary evidence is being relied on to prove a case. In this present scenario, the phone has been confiscated and it's part of the evidence matrix. The screenshots have merely been taken to highlight the intimidating aspect of the chats, and hence them refuting their originality or their existence do not mean that they do not exist, because these screenshots have been taken.
Phone has been taken, but where does it show that these screenshots are from that phone? How do you connect it? I'll make a screenshot and I'll give another phone.
Your Ladyship, it is an undisputed fact that these chats have been taken from the phone of the accused.
Mr. Prosecutor, kindly come to page 18.
Primary beneath. But that we are
Right.
told not to ask.
You are saying that in terms of PV Anwar, 3 judges bench, this piece of evidence is admissible at this stage without a certificate under section 65B, right? Now, this chat is done on a particular platform and a service provider. Is the service provider a witness before this court? Then what is the legal veracity of this document? That's correct.
Cassius has agreed that that was his phone that was taken.
Did you examine Cassius in the witness box? Did somebody examine Cassius?
We did, your Lordship, and we wanted to establish whether his phone was confiscated. His phone was a
Did you ask him in the cross that these are his chats?
Your Ladyship, taking into consideration the n number of frivolous allegations that all the defense accused have been making against the state, alleging torture, alleging police brutality when there isn't any, the prosecution believed it would be a futile question if they are simply going to lie about this as well.
Mr. Prosecutor, insofar as your charge of criminal conspiracy and reliance upon a chat on a signal platform, as is in the docket, why is there no cross-examination or suggestion or the attention of the witness brought to this chat when he is in witness box and an opportunity is available to you?
Your Lordships, all the evidence have already been presented before the court, and the defense has the clear indication as to what the evidences are. If
The witness only said that my phone was seized.
Indeed, but the witness has not, the defense has not paraded before any other question linking whether this chat was not found from the witness's phone. If the defense fails to make that motion, it is assumed.
It is your charge. You are making that assertion that this chat has been done by the accused, and this is a connecting piece of evidence to prove the criminal conspiracy. There is no cross-examination or suggestion to this effect. There is no service provider as a witness. The chat is a different piece of evidence in comparison to a voice record or a video or a photograph which is taken by a mobile phone. While as the latter may be primary evidence, a chat will still be a secondary evidence because it is done on a third-party platform. Lest the third-party platform proves the veracity of this chat, let him continue. If, for example, this chat was on Meta, WhatsApp, without producing that witness, the chat would be, even if found in the hard drive of a phone, would be still inadmissible. How are you then connecting this chat or this printout in the form of a chat as an evidence to bolster criminal conspiracy?
Your Lordship, counsel would like to reiterate the fact that these chats, it is an undisputed fact that these chats actually have been found from the accused's phone. Furthermore, these are merely screenshots highlighting the incriminating aspect of the chat. The chat is present in its entirety.
Now you just answer. What are the 4-5 legal points that come out in this case for you, and how do you disprove the points which are against you, the legal points? So one is conspiracy.
And if you would do that for each accused put to a trial,
That's all. Just
you
tell
have a
us
charge against 3 persons. Yes. So can you go one by one as how you prove the charge against the 3 accused one by one?
the
Yes.
conspiracy, the dying declaration, the statement which was made, the confession, its admissibility. So these are the 3-4 points that you have to prove, and how you can bring this unknown in it, right? So actually all that will come in conspiracy quad 3. Then you come with regard to the dying declaration. Forget the factual evidence. Then the dying, so just tell us legally one line on each proposition.
Also on murder.
Almost.
Also murder.
And
If your Lordship permits, I would like to begin with murder and then move on to
yes, whatever way you want to do it.
Your Lordships, your Ladyship, starting with the question of proving murder. Mr. Babula has clearly come on stand and mentioned that how he apprehended the accused, that is Mr. Silva. He saw him running, he ran behind him, caught him. As soon as he was caught, not taking into consideration whether he was actually the accused
Which limb of section 300 can you bring this under? I'll specifically ask you, if the whatever crime was committed to cause a bodily injury, and that bodily injury in the normal course of nature will cause death, then it's murder, right? In that case, what exactly would the court have to look at to satisfy itself? There's a Supreme Court case on this. Do you know Veer Singh was the state of Punjab? No, it's okay, fine. So you connect that murder weapon and DNA and all that and just finish your thing.
As has been provided in the forensic evidence, as has been given by the testimony of Miss Dr. Devi, that the deceased was stabbed 11 times in a frenzied manner. There were some minor wounds. There were some extremely fatal wounds. There was blood loss to that extent that the doctor was sure she would not make it. All these taken into consideration have to be added to the fact that he was seen leaving that crime scene, have to be added to the fact that he has confessed to the murder, have to be added to the fact that the murder weapon was found on his personnel. All of these have to be deemed irrefutable and enough evidence to prove prove the criteria under 302, Your Lordships. Furthermore, Your Lordships, the defense may contend that they will brutally, as I have been reiterating, they may contend that the confession was part of torture or anything, but they have not presented any evidence to prove their statement, and hence that has also not to be taken into consideration. Moving on to the next argument, whether conspiracy is done or not. Counsel would have to rely on the chats that has been found.
Any other evidence except chats?
Indeed, Your Lordship, Mr. Brutus, coming back to the confession of by the head constable. The moment he was apprehended, Mr. Brutus clearly mentioned, my co-conspirator will be found at the bus stand. His name is Cassius. The person to be found was Mr. Cassius. Furthermore,
And from Cassius, you seize a phone.
we seize a phone.
All right.
In those phone, we find these chats. These chats mention that commander has been giving him orders. Even if we don't take into consideration the relevancy of these facts, Mr. Brutus has confessed that they did this on the command of a commander. The commander is a mysterious figure that has not been clearly delineated in the present scenario. However, he has been described as a person holding numerous powerful positions and a man of considerable power. Mr. Alron has stated on the stand that he believes that in the state he holds.
Mr. Prosecutor, did you give a suggestion to Mr. Al when he came on the witness box that in terms of the chat, the man called as commander is nobody except you?
Indeed not, sir. Because that is not something.
Then how are we supposed to connect now the third man to the two men?
That is not something we can cogently connect even now, and counsel is not stating that that is the only
You
possible
just
argument.
argued that the third person who testified under 315 said that yes, I am the chief minister, I am Al, I am very powerful. That's all right. Every chief minister would be powerful. You are here trying to build a case of murder and criminal conspiracy and want that this court be, pleased to convict the third man as well on a 120B charge. But you did not give any suggestion. You did not give any suggestion on the chat at all. Do you have any independent evidence who is the third man who said that I was in my residence whole day?
Indeed, Your Lordship, to answer that line of question, counsel would first like to prove that Al is indeed Mr. Alron. If counsel can have 2 minutes of this court time, counsel would try to do that. First of all, Your Lordship, it is Mr. Alron has agreed in the witness box that he holds the administrative power over the state police in his state. Furthermore, we need to take into consideration the chats recovered from Miss Obstentia's phone.
He has power over the state police.
State police being the chief minister.
But also, then
So
he has
then
power
the
over
police,
you.
The police has exercised.
Indeed not,
The
Your Lordship.
police has gone and spoken against him.
Indeed not, Your Ladyship. There are 2 sets of police. Because of the nature of this state, there's one central police and then one that is state police.
Yes.
We can identify that as the moment Miss Obstentia was charged with criminal defamation. It is clearly mentioned that the state police hurriedly rushed to her apartment and arrested her and gave her house arrest and put her under house arrest.
But who surrounded the house? where was Babulal from the other police?
Indeed, Your Lordship.
Now, please go back to your argument at page 19. You wanted to show
Indeed, Your
something to us in the chat
Indeed, Your Lordship. Page number
of
9.
the deceased.
Indeed, Your Lordship.
Yes, please set up an argument.
Indeed, Your Lordship. Your Lordship, page number 19 and page number 20. Page number 19 and page number 20 read with 21. Clearly forms irrefutable proof that Al is indeed is equal to Al Ron. It is an undisputed fact that on the 20th, the moment Ms. Substantia gave her speech, a criminal defamation was filed against her.
All right. Mr. Prosecutor, please come to page 90.
Indeed,
You will classify this piece of evidence as what kind of evidence?
circumstantial evidence.
Sorry, this is a document. So, what is this evidence? This is a documentary piece of evidence. So, you would classify this as a documentary evidence to be proved under what provision? This is a document, it's not an oral testimony.
Indeed, Your Lordship.
Electronic evidence is a part of documentary evidence, correct?
Indeed, Your Lordship.
Now, therefore, is this document admissible under section 62?
Indeed, Your Lordship.
How?
Your Lordship, it is an undisputed fact that Ms. Substantia's, the court earlier has given permission to the police to go through Ms. Substantia's phone and find any incriminating evidence, if any, against possible accused.
All
And
right. Is this a chat?
Your Lordships, due to the constraint in the factual matrix, it is not
No
possible.
worry, you just now tell us whatever you want to.
All right. What's your
won't ask you more
sequitur
questions.
argument from this chat?
Indeed, Your Lordship. Your Lordship, on the 20th, a speech was made and a charge of criminal
All right.
defamation was filed. On the 22nd, it clearly mentions the nature of the chat. I am charged with criminal defamation? Question mark. Pathetic. That is how politics works. Now stop being a pig tease. This clearly proves as to the conversation happening between Ms. Substantia and Mr. Alron. It clearly means
It could be Alan as well, right? Why should it be Alron?
how could it possibly be Mr. Allen, sir? Mr. Allen is a vague figure who's probably
He's not vague. He's a general of a neighboring country.
Should prosecution have connected Al with whoever they wanted to blame? Should you have said, oh, she affectionately called this man Al?
Your Ladyship Counsel would contend that Mr. Alron had sufficient motive as well to murder Miss Substantia. He was going.
But why would she be in love with him? She said something.
Okay, you go to page 20 for a minute.
Why was she in love with him?
You
Your Ladyship, the nuances of politics
Love and hate.
no,
They would have moved together, I know, whoever would have won.
So, Mr. Prosecutor, just at page 20, just I wanted to point out something. You go 1, 2, 3, 4th chat there. Relax. That one. Can you read the later part? And don't call me normally. We might be tapped by your dear Anglovia. If it is this gentleman who's a CM of a state of Anglovia, why would he say your Anglovia? It's a foreigner, Alan. So therefore, he is saying your Anglovia.
Indeed, not, sir. He is the CM of Romulus, whereas Anglovia is the. Anglovia is a part of Romulus is the state. As like
you're saying Gujarat is not part of India.
Indeed, sir. Gujarat is part of India, but this chat clearly proves.
No, I'm not.
Mr. Prosecutor, do you in evidence prove beyond reasonable doubt the documentary piece of evidence at pages 19 and 20? Do you prove the documentary evidence at pages 19 and 20 strictly under section 62? In the absence of testimony of a third-party service provider. All right.
However, to answer your Lordship's questions to the earlier question, Anglovia, Mr. Alron was the Chief Minister of Romulus. Anglovia was the state in the country in which the submitted that the nature of the chats that has been taken from Ms. Substantia's phone. And the chat on page number 20, immediately following the tweet by Soldier Sable, clearly move on to prove how Mr. Alron had indeed a sway over Crusader's reborn. Soldier Sable clearly gave out a death penalty to Ms. Substantia. Mr. Cassius and Mr. Brutus have been hired by some supreme commander, whatever his name is, to commit the murder. They have been given a target. They have been given a mission, and they said there are a lot of constraints. The constraints being the two police officers right there, the biometric lock on the gates, which has been broken. The two police officers who have been evaded to go in, but they could not evade them fully, and they have been apprehended. All of these, your lordship, it is submitted that irrevocably proves to enough evidence to prove a case beyond reasonable doubt for criminal conspiracy as well.
Very well.
If there's no further questions, counsel, like to move on to the prayer.
Well, the prayer is office.
Is much of it.
Leave 3 of the accused or leave 2 of the accused? What is the prayer? Leave 3 of the accused or 2 of the accused?
Lifetime imprisonment for all 3 of them.
Are you not seeking a death penalty?
So due to paucity of time, it is much harder to prove Bachchan Singh and Machi Singh right now.
Well done, well said.
Much of it was truly an honor.
Defense arguments.
Come. Honorable bench. With the due permission of the honorable bench, the council will be addressing the honorable bench collectively as the honorable bench, individually as the lordship respective. Honorable bench, this case is not just of murder of democracy, but is also an expression by the state for zero tolerance of opposing ideology, especially when the flag bearer is a woman. It is my very humble submission, honorable bench, from brutality to violation of fundamental rights to violation of principles of natural justice to mockery of procedure in an absolute manner. The prosecution has clearly made and in fact established in the court that the prosecution does not respect the criminal justice system in the first place. It is my very humble submission, honorable bench, not just to mention the fabrication and planting of evidences by 2 constables who were drunk on duty, or to use better words, drinking on duty. Admittedly, the council will categorically be proving that every piece of evidence presented is not just inadmissible in the court of law, but also factually fabricated. It is my very humble submission, honorable bench, given that there are a lot of electronic evidences available, be it the chats of Miss Substantia, be it the chats of Commander with Cassius and Brutus. Despite that, not just to mention that 65B certificate has not been produced, despite the fact that Arjun Panditrao does exempt and does say that the certificate can be produced at any point of the procedure, but to the condition that the trial must not be prejudiced. It is my very humble submission, honorable bench, is that not just the certificates of 60B were not presented, there is no primary evidence on record. Honorable bench, my very humble submission, the fact sheet mentions that the CCTV of the bus stop was checked to spot Cassius. Where is the CCTV? Where are the mobile phones? Apparently, or probably, or possibly, my clients use a button phone. They do not even use WhatsApp. How is the court supposed to believe the prosecution story with no certificates and no primary evidences?
Madam Defense Counsel, how do you say that primary evidence has not been adduced by the prosecution? They have 2 sets of oral witnesses who are directly on the spot, who testify in primary the apprehending of the accused, your clients. They testify in court in terms of facts directly admissible under section 60. What part of primary evidence are you saying that the prosecution has failed to adduce to disbelieve the prosecution case?
Honorable Lordship, it is my very humble submission
there is a pending departmental inquiry against them. They were drunk or guilty, unreliable in the first place. It is a
How does a person who might have had a drink become unreliable just because he had a drink? And how are we supposed to disbelieve the fact of he apprehending the accused, the knife being recovered from your socks, the knife being then forensically examined and for a positive DNA, added to the situation and your contention that the defense during the cross-examination did not give any suggestion on the recovery of the knife at all from Brutus?
With the due permission of the Honorable Lordship, the submission that the council will be making will all be with respect to the knife. For the next 1 minute and 30 seconds, probably the council will be listing the problems with this evidence.
Okay.
My very humble submission, this is a recovery. Prosecution, why has the prosecution not produced the recovery memo? Where are the independent evidences? Why are there no signatures? Secondly, Honorable Bench, there has been a forensic science lab report, apparently. Two problems with that.
Yes.
Firstly, the head constable claims that the knife was blood stained, yet the forensic lab report says that there were only minor traces of blood in the corners of the knife, that too in the handle. This is the very direct proof of fabrication, attempt to clear the murder weapon. Additionally, my very humble submission, Honorable Bench, the forensic lab report does not mention fingerprints anywhere. There is no mention of the fingerprints. There is no proof that Brutus was handling that knife in the first place, let alone have his fingerprints on the knife.
Are we to then throw away a weapon just because fingerprints are not there?
Was the knife serrated?
And the autopsy doctor says that the injury was caused by a serrated weapon, including the knife.
My very humble submission, Honorable Bench. Firstly, given that these two are expert evidences and the experts are neither on oath nor there is an affidavit in the place, that raises serious doubts on the report itself. Secondly, my very humble submission, Honorable Bench, in the post-mortem report, if it is allowed, the council would like to navigate to the Honorable Bench exactly the words used in the post-mortem report.
Yes, at page 29.
Page number 30, Honorable Bench.
Yes.
Description of wounds. The third
witness said that I recovered the weapon from Brutus.
My very humble submission, Honorable Bench. It is the head constable
Who was drunk?
and who is soon facing departmental inquiry for this act in the first place. Not to mention the promotions pending from the last 2 years or 2 times.
How do you answer the fact that the letters A&N were also denied?
With respect to that, a very humble submission to your lordship is that, firstly, had it been that there was only one character with alphabets A and Al in his name, that could have been considered. But the problem is there is another one, that is Mr. Allen. My very humble submission is the council would like to draw the attention of the honorable court to the flags of the parties. Page number 26 and 27, honorable bench. It was pointed out by my colleague from prosecution that the party symbol for RSS is a rhombus, a plaintiff leaf and semicircle. On the next page there is an identical flag of no one other than Crusader Reborns.
And what does that suggest?
Honorable bench, it is my very humble submission that Crusader Reborn, it is mentioned in the factual matrix itself that Crusader Reborns was led by none other than Soldier Sable. In addition to that, the council would like to draw the attention of the honorable court to page number 24, which tells us about a newspaper clipping where General Allen met Sable. It is my very humble submission, honorable bench, that the prosecution has made a case by taking up Brutus and Cassius via Soldier Sable, reaching Mr. Alron, but Soldier Sable, this clipping is a live proof that Soldier Sable is not a mythical identity. This is a real person. If the newspaper knows it, why doesn't the police know it? And why is it that no charges has been framed against this person, and why is Mr. Alron being dragged in this particular situation?
Are you then choosing to rely upon this newspaper clipping to bolster your case?
Indeed.
Are you aware that a newspaper clipping is never admitted in evidence anywhere in the world?
Indeed.
Then how are you choosing to rely upon this?
Honorable bench, my very humble submission is that this is simply an inference to the fact that this is not a mythical identity. I'm not relying on the contents of the newspaper, honorable bench, but just that this happened.
This is filed by prosecution. This document is filed by prosecution.
If your lordship may be a little louder.
I'm saying this document, this press clipping is filed by prosecution.
I'm so sorry, honorable lordship, I did not get your question.
Was it filed?
Was this
this
filed by
document
prosecution?
filed by the prosecution or by the defense?
And
Whose
then-
document is this newspaper clipping?
My very humble submission, honorable bench. Firstly, given that we are limited by the proposition and the limited facts, and nowhere in the facts has been mentioned who has proposed this, an answer to contrary or acceptance.
All right, let us take it that prosecution filed this document. Then what would be your answer? Let us take that this document is filed by the prosecution. How would you then deal with this document as a defense counsel?
The very first and the foremost and the most important argument was pointed out by the honorable bench itself that a newspaper clipping is never admissible.
There is a corollary argument as well. A document placed by the prosecution, even if not proved, can be used by defense.
That is why I was asking you who has filed it.
That's where the question came from.
Filing is source of a document is very, very important.
So once prosecution files a document, the prosecution believes in that document. If prosecution drops that document, and if it is of some use to it, you can take use of that. All right.
Honorable bench. In addition to that, my very humble submission is that with respect to a very important evidence that the prosecution has relied upon is the dying declaration.
Okay.
It is my very humble submission that a dying declaration, though can be the sole basis of conviction injury report is present, whether there was a CT scan, was there an MRI, nothing is present on record, whether an anesthesia was given or not has not also been answered properly. My very humble submission is it raises serious questions. Honorable bench, it is also a little too convenient that everything points towards one person, Al, and the dying declaration is also Al.
Insofar as this dying declaration is concerned, you had Dr. Debbie testify. You had it for cross-examination. You did not ask a question to her that when she heard what the deceased told her, she didn't state it to other people who were around. Why?
Indeed, honorable bench, that should have been my course of action.
So then your argument could have been that it is only one person amongst at least more than 3 who were in close proximity. Now you have one witness, but not 3. But that suggestion was not given, that question was not asked. So how does the bench now disbelieve the positive assertion of Dr. Debbie is that I am stating to the court on oath what I heard from the deceased. That is directly admissible under 60. As a witness of fact, one who sees says I saw it, one who hears says on oath I heard it. So why should this witness now be disbelieved insofar as dying declaration is taken into consideration?
It is my very humble submission, honorable bench, that the state of mind of the deceased has not been proved. The burden of proof is on the prosecution. May they please prove to the court that
How else was the prosecution to prove the state of mind of the deceased?
Honorable bench, it is my very humble submission that there are clear guidelines of medical counsel is to prepare a BHT, that is to protect doctors like this from these cases so that they are not charged under negligence.
He produced a judgment that
negligence
documented.
ground is not being made. No, so don't give a wrong.
He produced a judgment that a dying declaration may not necessarily be documented. Even oral, in many dowry debt cases, sometimes a dying declaration is done figuratively, by suggestion, by pointing fingers. Those cases have been sustained and upheld. Why are we today to disbelieve Dr. Debbie insofar as what the deceased, before unfortunately dying, said to her?
Honorable bench, if I may continue.
Yes, no issues.
Honorable bench, my very humble submission still sticks to the fact that it is true, had there been recording of the statement, the evidentiary value would have increased. The counsel is not specifically stating that this is not admissible at all in the place, but that the evidentiary value is so low
You
that
did
it
not
cannot
give
be
a suggestion that you're lying, that the statement was never made to you. So today what you're saying is that we have then to necessarily hold that Dr. Debbie lied. How do we do that?
Honorable bench, as a young counsel, I'm still learning how to cross.
Summarize your points.
Okay.
Finish your points.
My very humble submission, honorable bench, at the conclusion of my statement and the closing statement is that all the evidences, though produced, I've not even discussed how the chats of Commander and Cassius and Brutus are factually and on the face of it fabricated. But my humble submission is that none of the evidences are conclusive proof, and there are major loopholes that prevent from a proper chain of circumstance to be made. It is my very humble submission, therefore, that the council pleads to the honorable court to pass an order for departmental inquiry against both the constables. In addition to that, against Mr. Constable Simba for perjury, because he stated on oath that they had only 1 flask when there was clearly 2 flasks, out of which they were drinking as per the proposition. In addition to that, all my 3 clients should be.
So
And any other order.
This is before recording an acquittal or after recording an acquittal?
First recording an acquittal, honorable.
That should be your first prayer.
Honorable.
Misdemeanor of a
Very good.
witness, misdemeanor of a witness during the performance of his duties is totally distinct from his mental faculties, isn't it?
Indeed.
So it may
judge's bench, I believe. What does that say? Even ill-gotten evidence can tomorrow be used for the purposes of convicting a man of a felony.
Indeed, Honorable.
Then just minor drinking would not take any sting on what he saw and what he did. Very well.
An honor to all. Thank you, everyone. This was wonderful. Both teams were excellent. And do we have to pronounce judgment just now? Oh, no. Do we have to pronounce judgment? Yes, of course, please. I'm sure we don't.
That was truly a remarkable display of oral advocacy, and we are certain the judges will have a hard time picking a winner. As our organizing committee has begun tallying the final scores, we request you to be patient with us for the next 10 to 15 minutes, following which we will be announcing the results. Thank you so much.
Where are you doing the results? Just tell them. Tell them that. They'll just go and come back. Babulal and Kesar.
I think Brutus, you can go for acting. You do theatre?
Thank you.
Thank you, everybody.
Yesterday, bro.